You get the call. You just inherited a home. Can you sell it for me? Before you grab your listing agreement, listen in. This episode could save you time, stress, and liability. Hi, everyone. I'm Ian Jones. I'm filling in for Mike Ferrante today. We're a team of agents located in Central and Northeast Ohio. And if you have any real estate needs, you can always go to 21mike.com and click on the button at the top to schedule an appointment with myself, with Mike, or with one of our awesome team members. If you're watching on YouTube, remember to hit the like and subscribe button so that you don't miss out on any of these agent training videos that we do every week. And like I said, my name's Ian Jones, and this week I'm joined by an excellent probate attorney who is here to help us understand the best practices that we can do as agents to make the sale of an inherited property go as smoothly as possible. But I want our guest to introduce himself. So T, who are you? Where are you? And what do you do?
Thank you, Mr. Jones. My name is T. Nadas. I have a small firm, Nadas Law, located in Cleveland Heights. I serve most of Northeast Ohio. I'm currently only barred in the state of Ohio. So just a quick couple of disclaimers, if it's all right. One, a lot of the advice and the information that I give today will be Ohio specific. Those who are tuning in from other states, the laws are probably similar, but not the same. So obviously check with local counsel. The second disclaimer is any of the advice that I give today is not to be construed as legal advice. I'm here to help educate, to shed some light on the background of what conversations should trigger certain thoughts. But please do not rely on anything that I say. Talk to the underwriters, talk to attorneys for the brokerage. I'm just here to give some broad high level.
Absolutely. We love a disclosure here. Of course, we want to make sure that we're not, practicing law if we're not able to as agents, but then also as yourself, you're just saying you're recommending we go to, another attorney, either locally if we're out of state or out of county, or to our brokerages, legal counsel, things like that. But no, that's all excellent. Today we're going to be talking about estate sales, probate, heirs, wills, all sorts of good things that can become a headache if you're not prepared. And so, T, this week, my biggest question for you is, you know, an heir to a property contacts you, the agent, saying they want to sell the home that they just inherited. What's one of the best ways to verify that somebody's actually legally allowed to do that?
So that's a really great question. So obviously here the most important question is title. Who owns title to the property, and who then has authority to sell that property? So saying an heir to an estate, that's kind of a loaded word. What is an heir? Heirs aren't always just assumed. There might be heirs by law. If there's no will, there might be heirs according to a will. An heir might not actually have the authority to sell a property. So there's a couple different things to look at here. So what I would say is a couple of things to think about. First and foremost, if you're able to see who has title to the property, check that. If it was the decedent, see if there's any transfer on deaths. If there was a transfer on death, then that's easy because whoever it transfers to, that's who has title to the property. That's who has the power to sell. If there isn't a transfer on death and it's still in the name of the decedent, ask them if there's a will. If there's a will, there's usually an executor named in that will. If the person calling you is the executor named in the will, then you can talk to them. If they're saying, "Hey, Dad left me the house, but Aunt Kathy is the executor," well, it doesn't matter if you're eventually going to get the house. The executor is the one that has the power to either transfer the house to the beneficiaries or ultimately has the power to sell. So I would just confirm. Just because somebody says I'm going to have it doesn't mean they do have it.
Mhm.
And then the third piece here is if there's no transfer on death, if there's no will, then at least in the state of Ohio and most other states, there will be laws of intestacy in terms of how property will transfer otherwise. So in a lot of cases, I think the last statistic I heard was over 50% of people die without a will. So there will definitely be cases that you run across where people say, "Hey, Dad died. I get the house and I want to sell it. Well, what does that mean, right? So, we talked about the other two options. If there's no will, then it's going to have to go through probate. And in the probate process itself, I'm sure some of you have dealt with it already in the past. It can be very mystical in terms of, you're just waiting for the lawyer to say, can I sell the property? And the bottom line is I'm going to just say, if there's a lawyer helping probate through the estate through probate, wait for the lawyer to say you could sell the property. But things to listen for, cues are, if there's no will and it's in probate and they're planning on selling the property out of probate, there needs to be consents to sell. There needs to be the inventories need to be filed with the court. There needs to be court approval. So bottom line is, don't just trust someone because they say I am the heir. Ask them for documentation, ask them for some sort of indication, some sort of proof, letters of authority, all of the above. But even then, still don't trust them, because the last thing that you want to do is get all of this information and say, well, they handed me a letter of authority saying they have all of this power. You get all the way to the end and the underwriter saying they can't do this, because then you are then stuck between the underwriter for the title company and the buyer and the seller, and everyone's yelling at you. And really and truly, you can do some of this legwork further up front, and um, and just get all this information, get it to your attorneys, have somebody else look at it.
Mhm.
Bottom line, unless you're hearing it from an attorney, I wouldn't trust it. I did see a question up on the chat, so I will respond to that very quickly. Yes, wills do go through probate court. So, in the state of Ohio, wills should be submitted to the probate court. The court actually looks at the will. They essentially give their stamp of approval, say, yes, this is a valid will. And then the will in and of itself isn't enough. They also need that additional authorization from the court saying that they are the duly appointed executor under the will to have power to sell.
Mhm. And that's where your letters of authority come in. Those will be distributed by the probate courts,
Yes,
correct?
they'll be issued by the court.
Okay, excellent. And what if somebody comes to you and says, "Well, I had power of attorney when, my mother was in the hospital, near the end of her time, and I had the power of attorney. I need to be uh, taking care of all the things sale wise with the house."
That's an excellent question, Ian. So, power of attorney, in its if truly what they say is I have power of attorney, like a financial power of attorney, general durable power of attorney, that dies with their mother. That dies with the decedent. So you cannot take a power of attorney and sell property with that power of attorney after the principal has passed. Have I seen it done in the past? I have. Is it rife with liability? It is. So if somebody says I have power of attorney, again, obviously double check with your lawyers, double check with everything. But if you hear I have power of attorney and mom died, or the decedent, this person passed, and now I'm just cleaning up everything and doing everything with power of attorney, hard stop.
Okay, good to know. Yeah, power of attorney ends when the 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 person dies. Good to know. Um, so now that you've proved somebody has like the legal authority to sell the house, is there any sort of like timeline or restrictions on when a property can actually be listed?
Yes. So obviously we talked about if there was a transfer on death, then there's really no restrictions, because then the title has passed. Whoever got the house has the power to sell. So there's nothing really to worry about there. If there is a will, and the will specifically grants authority to sell, and the will has already been submitted to the probate court and all of the above, and the executor has been appointed by the court, then the executor has that power under the will to sell. So really, there's no restriction from that perspective. If there's no will, so where it becomes the most restrictive here is there is no will, and the administrator of the estate. So I say administrator, there's an administrator of an estate. If there's no will, executor, if there is a will, the administrator of the estate then may decide that they want to sell this property for whatever reason. Maybe there's outstanding debts, maybe there's 20 heirs and they don't each want 1/20th of this property, whatever that reason is, they want to sell it out of probate and then distribute the assets after that. Here again, they need court approval. So the process here is first the court issues their letter of authority, then the administrator has to submit a complete inventory to the court, and the inventory needs to be approved. And then after that, they can submit what's called consents to sell, where every single beneficiary of the estate says, yes, we agree that we want the administrator to sell this property, and the court has to sign off on that. So if you ask me from a restriction standpoint, those are the restrictions. From a
Mhm.
timeline standpoint, if somebody says, hey, mom died yesterday, she has no will, and there are 20 heirs. And you, Ian Jones, were to say, hey, T, how long before I can actually get the authority or be able to sell this out of probate? The answer is, I would say minimum 6 months.
Yeah. That's kind of my understanding as well, is it is a lengthy process. We're obviously dealing with the court system. Um, and yeah, you know, when somebody calls you up and says, "Hey, I inherited a home and now I'm ready to sell it," not your first question is, "Are you legally allowed to?" Your second question is, "How far through the process have you gotten being able to actually go and
Right.
sell the
Like
property?"
if they come to you and they say, I was appointed by the court 6 months ago, I have consents to sell, I have
Mhm.
this, that, and the other thing, ask them for all the documentation, still share it with your lawyers, your brokerage, double check.
Mhm.
But that's a lot better than mom died yesterday.
Yes, exactly, which is what we're hoping to avoid, because I know it can get um I hate to use the word exciting because that's, never a fun word to use when we're talking about the passing of a loved one, but it can get confusing when you inherit a property, something valuable. That could be, a $50,000 house. It could be a $500 million house. It can be, um, you know, like I said, exciting, even though it's not exciting, to where you want to move faster than you're logically able to. And so,
And I know this isn't your job, and I would never, ever, ever tell you to do anything that is the practice of law. But I would just temper expectations. Somebody
mhm,
calls you and says, I want to sell the house tomorrow. Just say, okay, I understand that your loved one died and you inherited this house. There's a process and there's a procedure. I can't necessarily help you with that, but it might not be tomorrow that we can list it. So we
right.
still need to cross our T's, dot our I's, make sure that you have legal authority to do all of that before you can even, I mean, potentially even enter into a listing agreement.
Mhm. Yeah, absolutely. And that brings up kind of my next question as well. You mentioned executors, you mentioned administrators, um, letters of authority, all of that good stuff. But what happens if there are multiple heirs involved with a home? Are there any key legal or kind of communication steps that like the realtor should take to ensure that all parties, are on the same page? And I mean, if we have time,
So
we could
it
talk about it if there's even bad blood between the relatives. But
Good
go for
question.
it.
So again, starting with the easiest one, if there was a transfer on death and there are multiple parties listed there, then you would just treat it as any home that you're selling that has multiple title owners. So if there's,
Hmm.
10 kids, each of them has 1/10. Every single one of those 10 kids will then need to consent and be a part of this every step of the way.
Mhm.
Okay. If it's going through probate, so if it's if it's being sold under a will or just being sold out of probate, then it is the executor or the administrator's job to coordinate everything with the multiple heirs. So whether there's one heir or 20 heirs, you shouldn't have to worry about that. So like I said before, like wait until you are given some sort of documentation showing that there is authority. Clear that with your lawyers, obviously, but you have to wait for all of that. But you shouldn't be communicating with anything more than just that one point of contact. If, and I'm sure that this has happened. It happens to me sometimes too, where, cousin Timmy gets a 1/16th share and they're calling the realtor saying, "Hey, Ian, why isn't this sold yet?" I would just say, look, like, you don't have privity with them. You can't really share anything. Your conversation is with the administrator, and that's it. Um, do you want me to answer this question that just popped up?
Yeah, we had a great question in chat. So the question is, what about sale price? We see subject to probate approval. What does that mean? That's an excellent question.
So, can the court mandate a minimum sale price? When and why would that happen? So, again, I'm just talking broadly, state of Ohio laws as they stand today. In the state of Ohio, there are the real property has to be appraised before it is sold. And appraisal doesn't always mean we have to get an actual appraiser out there. The courts in the state of Ohio accept the county valuation should the executor or administrator say, yes, we are accepting this as the value of the house. At that point, what happens statutorily is that if you say, hey, Cuyahoga County says this house is worth $100,000, you cannot sell it for less than 80% of that value without court approval. So if you try to sell it for $75,000, the court, I mean, you can do it, but the court will get mad and may undo this or may ask for additional documentation. You're not supposed to. Okay.
Mhm.
So that would be the minimum sale price that the court is mandating. Really, it's the Ohio Revised Code is mandating. However, if you look at this house, you walk in and say, well, the county says it's worth $100,000, but I know I'm running comps. I see what condition it's in. It's not going to sell for more than 50. Then you have to go out and get an appraisal, and that appraisal needs to be approved by the court before the house can be sold. So there has to be an appraiser that is both licensed and also approved by that probate court. And then you submit that appraisal, and the court stamps it and says, okay, we understand that there's $50,000. The house is only worth $50,000, and that's what you're expecting to sell it at. And to be clear, this is all minimums. If you have a house that the county says is worth 100,000, you sell it for $1 million. Okay.
That's it.
No,
Yep. Yeah.
no,
Just it only works down, never up.
no worries.
Um,
And to answer Scott's question, going back to what we was talking about previously, if there's an executor or an administrator, they are your point of contact. They are signing everything, because technically what they are doing is they are standing in the place of the decedent. The house is still titled in the name of the estate. So let's say it's the estate of Joe Smith, as John Smith as the executor. So John Smith is standing in the place of Joe Smith. They are signing the fee agreement. They are signing the title. They are signing everything. And then the check is going to go to the estate of Joe Smith.
Gotcha. Yep, that makes absolute sense. And I have done a handful of estate sales, or handling the sale of a property with an executor in the past, and that is always how it has worked out for me. That means, to me, what that means is they had a will in place, which is already good news. There's usually an attorney involved, which is also good news. So I can ask questions about probate proceedings and things like that if I need to. And then also, of course, I have a point of contact who needs to sign off on the paperwork,
Yeah.
and it's just one person and not multiple people in different time zones and different states and all that good stuff, where it can get very, very complicated.
Yep.
Um, but let's say we get through all of that. We get the house listed on the market. We get an offer accepted, and then the title company opens up their title search and they start digging through things. I mean, is there any liens or title issues that come up when a house is specifically being sold, as an estate or through probate or anything like that?
The thing that will come up more often than not in state of Ohio again, is if there's a Medicaid lien. So a lot of times you'll have people who, at the end of their life, had to go to a nursing home, need additional home health, and they are out of money, but they can keep their house under the current laws. Then they essentially sign something telling Medicaid, hey, once I die, any of my assets that are left, you can get. So
Mhm.
one of the things uh, that title companies will do generally has been my experience is that when somebody passes and it is being sold out of an estate, they will double check to make sure that there are no Medicaid liens on the house. And what there should this step should have already been done by the attorney for the estate, if there was an attorney
Mhm.
for the estate. So the executor, administrator, whomever should have already recognized that this existed. But this is something that can come up. You should also know about any other mechanics liens or any other liens on the house beforehand. But by and large, you might see a Medicaid lien show up, at which point um, it will be either on the representative of the estate to work it out with the attorney general's office, or just the title company will just say, hey, there's $1 million lien on this house. It's being sold for $100,000. Thanks for all of your help, but Medicaid
Mhm.
is getting all of that money.
Yeah. So just like any other sort of lien, in order to provide clean title to another, to the buyer, those debts would have to be paid off out of the proceeds of the sale of the house. So whether it's $50,000, it's $1 million, whatever that looks like, you're paying off those liens first, and then any additional proceeds go to the estate, go to the executor, go to the heir, however it's structured after that.
Correct.
Excellent. Well, that's awesome. I mean, it's a complicated uh it can be a complicated situation. But if you have the right questions to ask, you have your ducks in a row and you're knowledgeable about how the process moves forward, I think it is a very common way of homes being sold. And I think it's something that we as real estate agents really should need to know a little bit more about. And I think we always like to say, if you're unsure, contact an attorney, talk to your broker, talk to your in-house legal counsel, or we can contact T as well, which I would like to know the best way to do that, and so would Mike here in chat. He would like to know the best way to reach out to you.
Because this is going up on the YouTubes and on the internets and everything, I would actually say if you have Ian's contact information,
Mm,
contact him and he'll get you over to me. I don't want to put all of my contact information out there right now. Uh, so that is the answer to that question. And the only
that's
other
fine.
thing that if that's okay. And
Yeah.
actually, so Mike, I saw that you put something in the chat. I can just send you a direct message, and I'll give you my contact information through there. And if anybody else wants it that is here right now, I can give you my contact information directly. So the other thing that I want to add to what Ian said is just think about certain trigger words, right?
Mhm.
If somebody says the word "not my house," "mom died," "out of the estate," "probate," just keep in mind that it's probably not going to be as easy and clear cut as "this is my house and I'm selling it." So just, pause, breathe, ask more questions, get more information, review it with your broker, with your attorneys, because if you don't do this on the front end, the issue will still arise. Something will come up on the back end, and you might potentially lose a buyer because of it, or just everyone's mad at you because you didn't ask the questions, even though you didn't
Right.
necessarily know to ask the questions. But ask the questions, make sure that you are sure that there is authority. And again, in an ideal world, the seller has counsel, and you can just confirm with their counsel. I get called all the time by realtors and brokers and underwriters saying, "Hey, do we have this, 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 and this?" And I say, "Yes, we do. Here you go," and it's done.
That's awesome. And yeah, I would agree. Ask all the questions up front. Make sure that you are uh, covering as many of your bases as you can ahead of time, because the last thing you want is to get to the closing table and somebody go, "Oh, actually, we can't sell this house." And then, like you said, everybody is mad at you. Um, but this has
Because
been
you are the
great.
face of the transaction no matter what.
Exactly. And we want to come off as knowledgeable. We want to be knowledgeable about these certain things because it does come up often enough that I think that it's important. So overall, T, I wanted to thank you for your time today. Thanks for hopping on this Zoom call and talking to us about probate and estate sales and the heirs and all the things that go along with that. It has been an absolute joy to have you here, and I always learn something whenever you and I have a conversation. It is always something new. We went through this yesterday, and I still learned something new today. So
Well,
if
it's a
that
pleasure and my honor. Thank you so much for the invitation.
Awesome. Well, thank you guys, everyone, for being here today as well. If you're on Facebook, if you're on Zoom, uh, share the video, do whatever you need to, and hopefully we will see everybody next week for next week's Tuesday training. And I appreciate all of you. Thanks, guys.
Thank you.